welcome to Bloomberg Quint. You're watching the Fineprint. In our top story this week, we are looking at 3 important insolvency law cases that have tested several firsts. Whether the Limitation Act applies to the Insolvency and Bankruptcy Code, the unique challenges that come with the insolvency process of a state-owned company, and complexities that arise when an employee initiates the insolvency process. Let's first start with how the courts have looked at the interplay between the Limitation Act and the Insolvency Code.
In August this year, the National Company Law Appellate Tribunal allowed initiation of insolvency proceedings against Neelkant Township. The company had resisted the proceedings on grounds that the financial creditors' debentures had matured in 2011, 2012 and 2013. And since 3 years had lapsed from the date of maturity of the debentures, Limitation Act will apply. The Limitation Act lays down time limits within which an aggrieved party can approach a court. The Appellate Tribunal held that the Limitation Act will not apply to insolvency proceedings. The matter then reached the Apex Court, which held that there were no reasons to interfere with the NCLAT ruling, but it specifically kept open the question of applicability of Limitation Act to insolvency law.
It's fairly standard for the Supreme Court, where they see that, there is some strength in the legal proposition. They leave that proposition open whilst dismissing the case on facts of a particular matter, which is what has happened in the Supreme Court case of the Neelkantan construction. In this case, basically what the Supreme Court has done by keeping the question of law open is by saying that, this issue is yet to be decided, and that the NCLAT order would only have a persuasive value.
Last month, the NCLAT had to deal with the same question in the Black Pearl Hotels case. This time, the Appellate Tribunal held that even if Limitation Act applied to the Insolvency Code, the application of the creditor would still not get hit by limitation. It held so on grounds that the limitation period for claims pre-existing the implementation of the Insolvency Code begins from December 1, 2016. That is, the date insolvency law came into force.
Now, we have to read the subsequent order of the NCLAT in this judgment which you just mentioned in line with the Supreme Court order, wherein the Supreme Court had clearly mentioned that the question of law to be remained open. Now, in that background, what the NCLAT has done is that it has assumed for the purpose of argument that even otherwise if the Limitation Act were to be applicable, I think it has rightly applied Article 137 of the Limitation Act to say that, for the purposes of its applicability, it would only apply when the right therein accrues. In this case, the Insolvency Code was notified on 1st of December. So for the purpose of accrual of the right for the purpose of initiating, the NCLAT has taken that date as the date from which the right can be accrued for the purpose of Limitation Act.
I think the consequences of this judgment is that several people who have missed their bus earlier by not applying under the winding up or any other provisions that may be applicable in a given case, they have suddenly a window open to try their luck under the Insolvency Code. But again, I don't think that's what the legislation or the NCLT want, that a flood of litigation for pending 30 years of debts coming to their dockets. So I don't think that should be and can be the understanding where somebody who has lost its substantive right or somebody has accrued a substantive right of not getting sued or not getting applied for bankruptcy can suddenly come under the new regime, just because the new regime has come, in 2016. So I think this requires some consideration.
Well, hopefully this consideration should happen soon, or else tribunals across the country may see a flood of litigation. The next case we're looking at this week is one where for the first time a state-owned company faced insolvency proceedings and just last week settled with its financial creditors. In May this year, Bank of Maharashtra had initiated insolvency proceedings against West Bengal Essential Commodities Supply Corporation. I asked Anil Goyal, the resolution professional appointed in the case, the unique challenges he faced through the insolvency process.
The difficulty that we faced was taking control and custody of the management of the company, and since this is a very large organization, still doing between 3,000 crore to 4,000 crores of turnover every year. And also, when we realized that the company has not got its accounts audited for the last 4 years, and the books of account of the company was also pending. So there was an information deficit with us. In the meantime, the company also made an application and filed an appeal before NCL 80. And company pleaded before NCL 80 that this is a public welfare company and it is engaged in the welfare of farmers, and also that the company is very, very sensitive politically, and it is actually impacting the interest of the farmers in case the corporate insolvency resolution process goes like this. So NCL 80 in this case ordered that in case all the financial creditors can provide you letter of satisfaction, then the corporate insolvency resolution process can be closed so that you start your operations normally. So with this order in hand, so in fact the operations of the corporate debtor was almost handed over back to them. So the management was operating completely the company as they were operating before CIRP started. Secondly, when I had meetings with them, so I said the only option that you have is now settle with the financial creditor. So in various meetings with the financial creditors and various COC meetings, each and every creditor finally settled with an amount which is due from the company, and the financial creditors also gave some waiver of interest amount. So with this mutual settlement between the company and the financial creditors, the company took approval from the government of West Bengal, and funds were arranged, and on 23rd October all the financial creditors were paid, and all the financial creditors provided to the company a letter of satisfaction and a no due certificate. So financial creditors in this case are very happy that they could recover their amount, which they were not able to recover for the last 7 years, and all the litigation was pending with the debt recovery tribunal, and a lot of efforts and money actually were being spent on that.
The creditors settled their dues and the company got back on its feet. A happy situation for both, but not so much for Goyal, who has an important lesson to share from his experience at a company where the control lies with the state government officials.
See, I will say that this is my first experience of handling a company which is owned by government, and also a company which is presently being managed by minister and principal secretary and an IAS officer. My experiences and my guide to my colleague insolvency professionals is that it is very, very sensitive to handle such companies. The most important part is that as a resolution professional or as interim resolution professional, we should not interfere into their process, into their procedure, into their method of working, because these companies are already structured companies. These companies are having their own processes for approvals and for expenses. So it is very, very sensitive. I can only share with you a little misunderstanding that the minister who actually is a director on this company have had. See, as every interim resolution professional is supposed to take control and custody of the bank account, and all the bank accounts of the company were actually operating, still it is operating under my control and under my signature, which is an understanding gap. So the officials of the company, they thought that this is something which is not desired, that a government company's bank account where huge money is lying and is being operated by a professional. The management of the company, after making payment to all the financial creditors, made a press release that they are filing an FIR against the bank and against the insolvency professional, because they had no knowledge about this law, and they thought that this taking over of the bank account and taking the fee, professional fee from the same bank account, is something which is a offence. So the minister gave a press release that in this case they are filing an FIR for this offence.
This threat of an FIR prompted Anil Goyal to file an application with the NCLT Kolkata bench for ratification of all the actions taken by him in the capacity of a resolution professional. Well, the final case we're going to talk about is one where perhaps for the first time an employee has dragged a company to court for failure to pay salary. Shivani Saxena reports on the facts of the case and its impact.
Nitin Gupta, an employee of Applied Electromagnetic, has triggered the insolvency process against the company. Employees are categorized as operational creditors under the Insolvency Code. Gupta argued before the Delhi bench of the NCLT that the company delayed his salary payments and today owes him over 46 lakh rupees. Gupta had first approached the Labour Law Department, and when he didn't get any respite there, he then resorted to the insolvency process for relief. The company rebutted Gupta's argument before the NCLT, stating that a portion of the claims are from 2008 and have therefore become time-barred. That is, the time within which Gupta could initiate legal action has lapsed. The company also argued that Gupta was forum shopping. The tribunal rejected both these arguments and allowed the petition on the ground that the portion of the claim is not time-barred, and this portion exceeds 1 lakh rupees, which is the minimum default amount under the Insolvency Code. It also rejected the forum shopping argument, saying that just because an unpaid employee has complained to the Labour Department does not mean he cannot initiate insolvency proceedings against his employer. By one estimate, the number of claims filed by operational creditors under the Insolvency Code so far has been nearly 3 times more than the claims filed by the financial creditors. This raises an important question. Is the code becoming more of a recovery tool? And if yes, is that in keeping with the objective of the law?
The code itself has that inherent flaw of having, by virtue of its provisions and operational creditors, employees as an example, and keeping the debt so low, has invited itself to be just a recovery tool, which it was never meant to be. So I think we need to seriously consider that and try and make sure that whether through amendment or otherwise, that you specifically say it's not a recovery tool, that you specifically put in mechanisms to ensure that it is not a tool for a recovery of dues, but is a tool for revival and restructuring.
Vishnu Jerome also told us about the challenges that this situation might throw up.
Huge challenge as far as employees is concerned is one, ability of unions to prop it up. And it's quite possible, may not be in a city like Bombay or Delhi, but quite possible in, just outside where you have larger factories that this could happen. Two, the challenge really is the employee not clearly understanding that he could prejudice himself and his own fellow employees by initiating the winding up proceeding, so the liquidation proceeding. The inability or the lack of awareness today of what the consequences are is something that I would certainly be worried if I was a promoter of a company, because I'm clearly not sure what my employee is aware of and understands the process of what he's doing.
We'll continue to track the progress of these cases right here on the fine print. Moving on. 2 entities that belong to the same group are recognized as a single economic entity under competition law. And so, agreements between such entities are not viewed as anti-competitive. But the Competition Commission of India seems to have set a confusing precedent by recognizing this principle in a merger case but denying it in a cartel case, and that too for the same set of parties. I'm talking about the Grasim Industries and Aditya Birla Chemicals case. The fine print asked experts if there is merit in the regulator's approach and its impact on businesses. The European Commission recognized the concept of single economic entity back in 1960s. It had held that a subsidiary company loses its ability to act independently when it's affiliated to a group. The US Supreme Court too upheld this principle in the Copperweld case on grounds that an internal agreement to implement a single firm's policies does not raise antitrust dangers. Back in India, the concept is viewed in the context of definition of a group.
We have a concept called a group, and a group is defined in terms of either shareholding or the number of directors on the board, or having control over the affairs and management of the other company. But this group concept originally was only captured in the provisions dealing with combinations, that is mergers and acquisitions. In the 2007 amendment, this got extended to the provisions dealing with abuse of dominant position. So there could be a dominance by a group of companies, not by a single company. And I think the first of the cases where I remember it did get a mention by CCI was in a matter against the Ministry of Railways and Concor, whether they belong to the same group or not. So in many merger cases, this group concept has been invoked and has been applied. When it comes to Section 3, there is no extension of the concept of group in Section 3. So that is one deviation that we make. And therefore, any investigation under Section 3 could very well mean that you can possibly ignore the group concept even though one gets influenced or is controlled by the other in certain specific circumstances.
But the regulator has applied the group concept in the past in the Lamborghini case while assessing conduct under Section 3 that prohibits anti-competitive agreements.
There was a complaint of alleged cartelization against Volkswagen and the Lamborghini Group. The CCI evaluated it and said that since both Volkswagen India and Lamborghini belong to the same group, therefore they're part of a single economic entity and there's no question of cartelization. It's merely an internal arrangement of the group from a business perspective, and they would not look at it as an agreement at all.
But while assessing the conduct of Grasim Industries and Aditya Birla Chemicals under Section 3 itself, the regulator deviated from its position in the Lamborghini Group case.
In a recent order, the CCI found Grasim Industries and Aditya Birla Chemicals guilty of bid rigging a Delhi Jal Board tender. The regulator rejected the argument of the companies that there can't be collusion since they are part of the same group and hence constitute a single economic entity. It held that since public procurement involves use of taxpayers' money and consumer welfare, bid rigging should be viewed as one of the most pernicious anti-competitive conduct, inviting serious penalty to serve as a deterrent. Now, rewind to 2015, when the CCI had approved the merger of Aditya Birla Chemicals and Grasim. At that time too, the companies had argued that since they are a single economic entity with common leadership, executive management, marketing, procurement and HR team, the merger will not have any appreciable adverse effect on the market. The regulator had accepted this argument then.
So, in ruling that Grasim and Aditya Birla Chemicals are a single economic entity for merger control purposes but not cartel purposes, has the CCI set a confusing precedent?
It sets a very confusing precedent because at the end of the day, clarity and consistency is required when there is a single legislation. And here the Competition Act is the only legislation which governs competition law. So therefore, to have differing standards on what would constitute group and single economic entity for the purposes of merger control and abuse of dominance, vis-a-vis what would constitute group and single economic entity for the purposes of cartels, would create a lot of inconsistency in the market. The CCI seems to have taken a stance that because public procurement involves taxpayers' money, therefore, the concept of a single economic entity would not be applicable in cases where alleged cartels were being investigated if a particular business house used more than one legal entity to effectively bid for a tender. And that will create a lot of problems from a pure business point of view. This view that the CCI has taken is not in line with international jurisprudence because both the US and the European Union are very clear in terms of the concept of a single economic entity, and that if there is a single economic entity, there is no question of there being a cartel at all, because you cannot have an agreement with yourself, right? In order to have an agreement, you need more than one entity, and the rule of thumb is that these entities have to be independent.
In considering this requirement of independence, the regulator pointed out that though Grasim and Aditya Birla Chemicals had common shareholders, employees, etc., they participated in the tender as separate entities. It pointed out that where two or more entities of the same group decide to separately submit bids in the same tender, they have consciously decided to represent themselves as independent options for procurement. But experts point out that in a lot of cases, public sector procurers force bidders to do so.
It is not uncommon for procurers to push the tenderers to bring in more bids so as to have a bare minimum, and so that nobody points a finger at them that they identified or selected a bidder which was not the best. And as far as I know, it is quite rampant. It's not only in this case, but maybe many other places that this kind of push from the procurer does happen. Whether they will stop doing it, I don't think, because they are not being penalized. Whether the companies will stop behaving like this, well, is again depends upon, do they have a choice? If they are going to be bidding where there cannot be many bidders, and I'm aware of some cases where technically only one person can bid or only two parties can bid, so they have to conjure up with some third bidder who is not a serious bidder just to have the quorum or the number of minimum bids complete.
So, what's the solution? Experts you just heard suggested that on its part, the CCI should use its advocacy program to educate public sector procurers against this behavior. And until that happens, companies should make the procurer aware of the fact that they belong to the same group, specifically mention this in the tender documents, and use it as a defense if it comes to that. Something that Grasim Industries and Aditya Birla Chemicals couldn't do, as the fact of their common ownership was not recorded in the tender documents. Well, that's all on this week's show, but do visit Bloomberg Quint's Law and Policy page to listen to an exclusive talk by India's top banker Uday Kotak, who said that the Sevi Committee on Corporate Governance that he chaired took an evolutionary, not revolutionary approach to how listed companies are run. Thanks so much for joining. We'll see you next week.
Our focus has been on outcomes and less on who implements it. We are quite open whether SEBI implements the recommendations or in some cases Ministry of Corporate Affairs. Therefore, we are quite agnostic to which part of the regulatory bodies decide to implement which recommendations. And therefore, we just wanted to also ensure by stating that in the report that we are outside, we don't want to be in what may be potentially tough areas, but want to focus on more what is right for governance of listed companies and not necessarily who implements what recommendation. So that was one general approach which we took, and we did most of the cases we did a zero-based approach to this and tried to come out with what we thought was the right recommendations. And the second, in fact, as Ishat was just mentioning to me over coffee, that a lot of progress has been made in the area of governance over the years, from where we were in the 90s to where we are. And therefore, our approach to recommendations has been evolutionary and not revolutionary, because I think change in the whole governance framework which we do has to be something which has to modulate with the ability of the system to adjust. And very often when the system tries to do too many things, it actually creates disproportionate friction. And we just felt that the evolutionary was the right way to go in terms of implementation rather than revolutionary. And therefore, many of our recommendations have given reasonable timelines for implementation as well. And therefore, for each recommendation, we have suggested a potential timeline, and it's spread over between 1 and 3 years, and in some cases even longer.